Thank you, everybody, for joining us today. My name is Jie Huang. I am a senior associate at Scott Legal PC. Today, we are going to spend some time talking about the visa options available for individuals who have extraordinary ability in their fields. So just a few things before we get started. Scott Legal is a full-service immigration law firm, which means we have expertise handling a wide variety of non-immigrant and immigrant visa categories suited for various circumstances. So whatever your immigration needs may be it a family-based, employment-based, or investment-based immigration matter, we can help you find a solution. We will be continuing these webinar series. We are doing at least 2 webinars a month on different immigration law topics. And at the end of this webinar, we will be sending out a few things to all participants. First, we will be sending out a copy of the PowerPoint, which will be used in this webinar. Second, we will send everyone a comprehensive visa guide about the categories of visas that we will be talking about today. We will also send you a link where you can follow to sign up for additional webinars in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we do encourage you to subscribe to our YouTube channel and hit the notification button as we do regularly upload immigration law related videos. Finally, we will send you a link which you can follow to set up a consultation with one of our experienced attorneys should you wish to discuss your matter further. So today we are very lucky to have Kelly Weiner, who is the managing attorney of the firm with a wealth of experience handling cases in all of the visa categories that we will be speaking about today, who will be presenting about these various options available to extraordinary ability individuals and the requirements and considerations. Finally, for any questions you may have, please feel free to add them to the chat box or use the Q&A function, and we will try and get to all questions. So without further delay, I will turn it over to Kelly.
Thank you, Jie. Perfect. Good morning, everyone. So we're going to get started just talking a little bit about what are the extraordinary ability visa categories. And we'll go into more detail on each of these in the following slides. But just as a general overview, we have the O-1A visa. This is for people who are at the very top of their field in sciences, education, business, or athletics. And the standard for this is relatively high. The person must be one of a small percentage who've risen to the very top of their field. The other type of visa that you hear about at the O-1 context is the O-1B, and this is really for the arts. And within that, there's a couple different subcategories. So extraordinary ability in the arts or extraordinary achievement in motion picture or television industry. And the standard for the arts is a bit different. So for the arts, you have to show that you have distinction in your field. So this is described as a high level of achievement as evidenced by a degree of skill and recognition substantially above that ordinarily encountered. So this is different than the O-1A standard, a bit more permissive, for the arts than it is for the O-1A visa. And then the standard for motion picture in the television industry, this is a bit higher. Someone has to have reached a level of acclaim substantially above that of his or her peers. So depending on which category you are applying in, you want to make sure that, you've kind of defined, are you going under arts? Are you going under business? Sometimes there is, kind of an option or a question about which category you're going to go in. So perhaps if, you have a case that's a bit weaker, perhaps you want to try to go under the arts category because the standard is a little bit different than for the O-1, the O-1A. So then the other one we'll talk about is the EB-1A green card. So, when people come on an O-1 visa, this is often the green card that they think of as kind of the potential option for them in the future. So for the EB-1A, this encompasses sciences, arts, education, business, or athletics. So for O-1A and O-1B, we have a split between, business, sciences, and arts. For the EB-1A, it's going to encompass all of those fields. And so this is, the standard for this, it's a green card category. So the standard is higher than that for the O-1A and the O-1B. So just because you've received an O-1A or an O-1B, that doesn't mean you're automatically going to qualify for an EB-1A. You might, however, they do have kind of different standards, even though the requirements are very similar. So for the standard for the EB-1A green card, you have to, be an individual who've risen to the very top of your field of endeavor with sustained national or international acclaim. Your achievements need to have been recognized in your field of expertise. And then for all three categories, you have to show you're going to be working in your area of extraordinary ability. So for the O-1A and the O-1B, that might look like, you include an itinerary, you include contracts that show that you have enough work in your area of extraordinary ability, for up to 3 years, which is the longest that the O-1, can be approved for. For the EB-1A, you would include a statement showing that you have, current and future plans to continue working in your area of extraordinary ability. Because if the EB-1A is granted, then, you'll get a green card and you'll be able to live and work in the United States indefinitely. All right, so let's talk a little bit more about the O-1A requirements. So to qualify for the O-1A, you either need to demonstrate you've received a major internationally recognized award, for example, a Nobel Prize, Pulitzer Prize, or much more commonly, you're going to show evidence of at least 3 of the following, so receipt of prizes or awards, membership in associations in your field which require outstanding achievements, published materials and professional or major trade publications about you and your work in the field, original contributions in your area, authorship of scholarly articles, high salary, participation on panels, or individually as a judge of the work of others, or employment in a critical or essential capacity for organizations that have a distinguished reputation. There's also an ability to add in other comparable evidence if none of these, are as relevant within your particular field. Although I think it can sometimes be hard to argue that, the field doesn't have these types of, associations. Another thing to consider, and we'll talk a little bit more about this later, is it's not enough to just meet the plain language of the of the regulation. So let's say that you've won some prizes, you're a member in some associations, and you've written 2 articles. So that alone is not going to be enough to qualify for an O-1A. There's kind of a 2-step analysis that they do when they look at, the evidence here. So one is, have you met the plain language? Have you provided evidence that you have prizes or awards? And then the other is, taken in totality, looking at all the circumstances, does winning this prize indicate that you are one of the people who has risen to the very top of your field? So for example, if you're a student and you won an award, while you were at your university that's given only to students, this is not going to be very compelling evidence. So you always have to think about not only do I have the evidence, but then how valuable is that evidence? Ideally, you want to show that you are, winning prizes or awards, that those are being given by organizations that have very, kind of strict criteria, that are only giving prizes to the very best in the field, that have judges who are experts in the industry. Similarly, if you're a member in associations in your field which require outstanding achievements, you want to be able to show what are the membership criteria. If this is something where you just pay an annual fee and, you prove that you, for example, are a lawyer and you have a law license, so you pay an annual fee and you're a member of a bar association, that's not going to be a good piece of evidence for an O-1A application. It really needs to be something where perhaps, only the best and brightest in the industry are invited. You have to show some level of achievement within your field in order to be granted membership. So you always want to be thinking about that when you're providing your evidence. It's not enough to just kind of meet the language. You need to also, prove why it shows that you are an individual of extraordinary ability. So let's look at O-1B, somewhat similar. So, you must demonstrate either, nominated or received a significant national or international award in your field, an Emmy, a Grammy, or again, evidence of at least 3 of the following. And you can see that there's some similarities, but there's some differences because this is focused on the arts. So there's criteria that make more sense for people in the arts. For example, evidence of performing a lead, starring, or critical role, evidence of a record of major commercially or critically acclaimed success in the performing arts. So this is going to be more specific and geared towards, people with an arts background and relevant to kind of the arts industry. As with the O-1A, ideally you want to show that you're meeting as many as possible. So at least 3 is the requirement, but if you can show that you have more, that's obviously, better. And also similar to the O-1A, it's not enough to just show that you meet the plain language of the regulation. You also have to show why that indicates that you are someone who's risen to this level of distinction within your field. So you always want to be thinking about what is the quality of the evidence I'm providing? How does it show that I'm somebody who's achieved distinction or achieved sustained national or international acclaim? All right, so what is the difference between O-1A and O-1B? So here we have a little chart that kind of breaks it down. The fields are different. So O-1A is science, education, business, or athletics. O-1B is arts and motion picture television industry. What are the standards? For the O-1A, one of a small percentage who've risen to the very top of your field of endeavor. For O-1B, the arts is going to be a high level of achievement, that distinction standard, and motion picture is going to be a level of acclaim substantially above that of your peers. And then these last ones show the similarities between the O-1A and O-1B, so they can be issued for the same length of time. So initial visas can be granted for 3 years, and then you can get extensions. If you're just extending, a particular engagement, generally you can only get 1 year. If you're starting a brand new project, you're working for a new employer or the same employer with a new itinerary, sometimes you can also be eligible for an additional 3 years. And there's no kind of limit on it. You can continue to work in this area as long as you have extraordinary ability work available to you. And your family can also come to the US and join you. Children can attend school, spouses can as well, although spouses are not permitted to work in the United States. And then the EB-1A green card, requirements are very similar to the O-1A or an O-1B. However, it's a green card. So the standard is obviously going to be, significantly elevated. And here's where that step 1 and step 2 analysis that we've been talking about with O-1A, that's also going to be relevant for the EB-1A. So they're going to look at your evidence to see if you've, won that award or you meet 3 of those criteria. And then they're going to go beyond that to look at the quality of your evidence. So in totality, are you one of a very small percentage of people who've risen to the very top of your field of endeavor? So there should be, people who are getting the EB-1A. These are people where if you, do an internet search for this person's name, generally you would expect that their name would come up, in their industry. These are things where, if your industry is the type that doesn't have a lot of published material, that's something you can certainly argue. But, when we talk to clients who are perhaps doing relatively well in their fields, but not yet at the EB-1A, but want to work towards it, we do recommend that you take a look at that criteria and you try to build some of that into your career development, right? So, join those memberships, write articles when you're invited to do so, kind of seek out opportunities to be on, prestigious panels or to judge the work of others in kind of high profile events. These are all types of things that perhaps as people, kind of progress in their careers, they may be invited to do these things and may not necessarily take advantage of those opportunities. But those are really good things to take advantage of if the EB-1A is something you're working towards, in the future. So now we will switch gears a little bit and talk about the National Interest Waiver, which is another great green card option that can be available to people, maybe who are not quite at the EB-1A level, but has some other different, kind of criteria. So GA will talk about that.
Yeah, sure thing. Thank you, Kelly. Yeah, so the EB-2 National Interest Waiver is another green card category. It's under the EB-2 category, but the special thing is that people who qualify for the NIW can self-petition for a green card without needing a U.S. Company to sponsor them. So that's in that way, it's similar to the EB-1A green card, which people can also self-petition under. So let's talk a little bit about the requirements of how to qualify for the EB-2 National Interest Waiver green card. So first, as a minimum, before even getting to the national interest waiver category, the individual must need to meet the EB-2 category threshold requirement. So how do you meet the threshold requirement? Either by showing that the individual has an advanced degree or its equivalent. So advanced degree is defined as a master's degree or an above. So for example, master's degree in science, master's in arts, PhD degree, MBA, Master's in Business Administration, a JD or an MD could also apply because to gain admission to those programs, you need to have a bachelor's already. So that's included in the definition of an advanced degree. Also, if you have a bachelor's degree in your field, and if you have over 5 years of progressive work experience after you received your bachelor's degree, that can also be considered as an equivalent of a master's, so equivalent of an advanced degree. So progressive work experience here means that the work duties have changed to include more senior duties and more complex duties over time. So you would want to get letters from your employers proving how your duties have changed and how long you have worked in each position. So that's one way you can meet the EB-2 threshold requirement. Now, the other way you can meet the EB-2 threshold requirement is by showing that you have an exceptional ability in the sciences, arts, or business. And so what does exceptional ability mean? And as a beginning, I think it would be important to share that exceptional ability is very different from extraordinary ability. So exceptional ability is defined as a degree of expertise that is significantly above that is ordinarily encountered in the field. And that is certainly very different from the standard that is used in the EB-1A context, extraordinary ability, which asks for someone to have had sustained national or international acclaim to be considered someone who is at the very top of their fields. So how do you show that you have exceptional ability? You can show that you meet 3 out of 7 criteria of evidence, some of which includes, for example, 10 years of experience in your field. It can also include evidence of recognition for your achievements in your field by your peers, by the industry, by government actors, or by showing that you command a higher salary than others in your field. The totality of this evidence must show that you're operating at a level that is significantly above your peers. So just by providing great services to your clients, for example, would not be enough. You would need to show that you are contributing to the industry or field as a front runner in some way that distinguishes you from others. Now, let's say you meet the EB-2 threshold either by showing that you have an advanced degree or by showing that you have exceptional ability. Now, the meat of the application is showing that the person actually qualifies for the National Interest Waiver, right? And how do you show that you qualify for the National Interest Waiver? You follow the 3-prong test promulgated by the case called Matter of Danisar. And the 3 criteria is as follows. First, the individual's proposed endeavor must be shown to have substantial merit and national importance. Now, what does that mean? So substantial merit can be shown in a wide variety of fields, including business, healthcare, education, science, technology, for example. And endeavors, for example, that further human knowledge in those key areas, such as medical advances or civil engineering, can be shown to have substantial merit and national importance. Now, another way you can show substantial merit and national importance is by showing that your endeavor could have a strong economic impact, a positive economic impact to the regional or national economy as a whole. And really the argument that you want to consider is, what is the future impact of the work that you propose to do in the United States? Are you doing some research that will advance technology in a particular field that the government thinks is important, such as the design of semiconductor devices or, electric vehicle engine technology or things like that? the stronger the argument you can make on your potential impact, the stronger case you will have for a national interest waiver. For example, you can include government reports and executive orders for evidence of why certain sectors, certain areas are really key for U.S. national interest, and that would be helpful for your application. Now, the second criteria for the national interest waiver is that the individual themselves, you are well positioned to advance the endeavor. And what does this mean? It means that the individual must provide evidence that they have relevant education, they have relevant experience, and that they do have a record of success in previous related projects that will position them well to advance the endeavor that we evaluated whether it had substantial merit and national importance. Finally, the third requirement is that on balance, it should be beneficial to the United States to waive the requirements of a labor certification for that particular individual and for that particular case, because ordinarily the EB-2 category is for employer-sponsored immigration, and we need something plus alpha from that to show why this ordinary labor certification is either too burdensome, too time-consuming, or the benefits of having that individual come to the United States outweighs the ordinary benefits of having that labor certification requirement. So there are a few ways you can argue you can support your case in this prong. For example, you can rely on substantial merit and national importance of the proposed endeavor and emphasize the broad systemic benefits that your work can have to the field as a whole. You can also bring in some arguments from prong 2, well-positioned, talking about how the individual themselves have the unique know-how and experience that other United States workers with minimum qualifications may not have. So it would be beneficial to bring you in so that you can share such unique insights. Special considerations can also apply to support your case on prong 3. For example, if you're an entrepreneur and if your business offers substantial economic benefits to the United States, for example, contributing to significant tax revenues for the region, and also resulting in significant job creation for U.S. workers, that could be a positive factor on balance that could really support your case. All right, we can move on to the next slide. So let's then now talk a little bit about the importance of expert opinion letters in those extraordinary ability types visas and green cards. Expert opinion letters are relevant for both O-1, EB-1A, and also NIW petitions. The purpose is a little different for each category. So for example, for the EB-1A and O-1A categories, you would want the expert opinion letters to confirm and explain how you have extraordinary ability in the field and is well known in the field, and has sustained that national and international acclaim that is required to qualify under that category. For the national interest waiver, for example, the expert opinion letters can provide more context about the importance of your proposed endeavor in the United States, such as a letter from a government agency, for example. If you're an individual who is proposing a project in agriculture, you could get a letter of support from the USDA, for example, and that individual could talk as an expert about what you're proposing to do, explain why it's important to the United States, and it also explain what are the potential impact your work could have to the field as a whole. And that could really be a powerful form of evidence to support the merits of your case. Now, another type of letter that could be relevant for the NIW is letters that talk about your achievements in the field and how you are well positioned to advance the endeavor. So for example, you could get letters from previous employers confirming your leading role in a particular project that resulted in a significant impact to the field, such as the development of a patented technology that was commercialized, or a research project that received a lot of attention from other experts and resulted in progressing the field as a whole. So those kinds of letters can also be very helpful to support prong 2 of a national interest waiver case. Now let's talk a little bit about who is writing the letter. So ideally you want to get letters from experts who are at a leading stature in the field, who have decades of experience. We would typically attach their full curriculum vitae, their resume to the petition to show the extent of those credentials. And individuals who are in senior positions at leading organizations, relevant industry or government organizations, for example, could be helpful, especially for the NIW. Letters coming from an individual working at a government agency can be very favorable to support your case. Now, also another consideration is, how does the individual know you? So we typically advise clients to have a mix of independent experts and inner circle experts. Inner circle experts are experts who have worked with you before, and so they can speak in detail about your achievements in the past and what importance those achievements were to the field. Independent experts are people who don't personally know you or have directly worked with you before, but they know you through your work or through your reputation in the industry. And these types of independent letters can be very helpful to support, that your abilities are outstanding in the field, or also that you yourself are well known as a figure of sustained national or international acclaim. Because if you have that acclaim, it is very likely that someone in the field will know you, even if they have not directly worked with you before or have not personally be connected with you. Now, then for the last point, let's talk a little bit about the content of those letters. So in those letters, having the specific discussion about your work is very important. And letters, that are formulaic or simply repeat the regulatory language are known to not be effective. So for example, the letter should not just say, applicant is a well-known figure, or just say that the applicant's project has national importance without the supporting details, because conclusory statements are not relied upon by USCIS. So it is very important to have the letters discuss specific examples of your work, because those examples can show why you are extraordinary or why your project has national importance. So things that you can talk about is, what exactly did you do in your field? What problem or limitation did your work solve? How did you solve this problem in an original way that is different from others in the field? And how has your work been shared with others? How has this work been received by the public? Things like that are very important to have the right level of detail. So now we can move on to the next slide. So which category should I apply for? So there are a couple of considerations that could be relevant on choosing the category. We have discussed a variety of categories. We have discussed the O-1 categories, the EB-1A. We've discussed the EB-2 NIW. Now, one question is, do you want to stay in the United States temporarily or permanently? So one thing to note is that if you need to travel in and out, and if you spend significant time outside the United States, the O-1A or O-1B could be a good option for you. Timing is also an option. Timing is also a consideration, because the O-1A, O-1Bs are non-immigrant visas and can be faster to get. O-1A, O-1B visas, you can continue to renew those visas for 3 years or 1 year at a time, as Kelly mentioned before. There is no lifetime limitation on how long you can be on an O-1 visa. So this can be a good option and could support you for many years in total. The EB-1A and NIW are both green card options. So this is really for people who want to live and work in the United States permanently. And if you become a permanent resident, there are also restrictions on, how long you can stay outside the United States and things like that. So this is really good if your plan is to remain in the United States on a permanent long-term basis. And also, if you eventually want to, obtain U.S. citizenship, the EB-1A and NIW are green cards. 5 years after you receive your green card and, meet the physical residency requirements, you can apply for U.S. citizenship. So that could also be one consideration regarding future plans. Now, another question you want to ask is, do you have a U.S. employer or agent who can act as a petitioner for your case, or are you self-petitioning? So the O1 and O1A and O1B categories require a U.S. entity or U.S. individual to act as the petitioner, either as an entity or an individual, as an employer or an agent. So you do need to have that structure. It is possible for an individual to, have a U.S. company that they own, and that U.S. company can act as the petitioner for an O1A petition, for example. That is possible. So ownership of the entity is not, a problem there. But you do need to have that legal structure. For the EB-1A and the EB-2 NIW green card, you are allowed to self-petition, which means the individual who is the beneficiary, who is going to get the visa, can act as the petitioner. So you can drive the petition. You don't need to have a U.S. entity or any other U.S. connection to start your case. Now, let's talk a little bit then about family. For the O1A and O1B, your spouse and children can accompany you to the United States. They can get the O3 dependent visa. However, the spouse beneficiary of the O3 visa cannot work in the United States, so that can be a limitation for many people. For the EB-1A and NIW, both, as I mentioned, are green card options, which means your dependent children and your spouse can also receive green cards as, derivative beneficiaries. So they can also, obtain green cards through that process, which could be a great advantage for some people. All right, so we can move on. Considerations when moving from a non-immigrant visa to a green card. Right, so we do see a lot of cases where some of our clients are already on an O1 visa, and they want to eventually move to a green card, either through the EB-2 NIW category or an EB-1A. Let's talk a little bit about what are the strategic considerations involved. So qualifications. As Kelly mentioned before, the EB-1A is a green card category, and it is the first preference green card category. So it is judged with a higher standard than the O1A, O1B, which is the underlying, which is the similarly phrased non-immigrant visa option. So especially if you are going from an O1B to an EB-1A, right? O1B only requires distinction in the field, whereas EB-1A requires showing a sustained national or international acclaim. So those languages already are quite different, and it can be a big jump in terms of qualifications. So as Kelly mentioned before, it may be necessary to spend a couple of years really strengthening your portfolio before you can apply for a green card under the EB-1A category. Let's talk a little bit about timing. So think a little bit about what is your underlying visa and when do you want to file for a green card, if that is your goal. And think about when does your non-immigrant visa end. And so if you need to renew your non-immigrant visa soon, it could be a good strategy to wait before you actually renew, before filing the I-140. Because certain types of non-immigrant visas, you need to always be showing that you have non-immigrant intent. For example, let's talk about the TN visa. for the TN visa, you always need to show that your intent is to work for short term in the United States and then return to your home country after your work arrangement is over. Now, if you have already filed an I-140, which is, the petition for an immigrant visa, petition for immigrant classification in either, the EB-2 or an EB-1A category, that can be an indicator that you actually have immigrant intent, that you want to stay in the United States for long term, instead of just intending that you would, work in the United States and leave. So that could, pose complications for future renewals for certain non-immigrant visas that you have. So definitely speak to your attorney. If your plan is to apply for a green card, apply for, immigrant classification, adjustment needs to be done with regards to timing to maximize the strategy. O-1 visas usually, is understood as a quasi-dual intent visa. So there are certain types of visas for which immigrant intent is not a problem, and the H-1B is one of these categories. The L-1 is another one, and the O is, understood as a quasi-dual intent. So you could be okay there, but before doing so, definitely a good idea to speak with your attorney. Let's then talk about family then. So family could be another consideration on how to, determine the timing of when you want to apply for an immigrant visa petition. If you have children, for example, who also need the green card, dependent green cards are available for children who are under 21 and unmarried. So if your child is turning 21 soon, it may be another consideration that would shorten the timing where you would want to apply sooner than you may otherwise. All right, so then we can move on to the next slide. So the question there now is, are extraordinary ability categories available for entrepreneurs? And the answer is yes. The EB-1A and NIW are categories that both allow for self-petitioning, as I mentioned before, meaning that entrepreneurs could take advantage of those categories even if they do not have a job offer from a U.S. entity apart from themselves. Let's talk a little bit about changes in the EB-2 NIW standard under matter of Danisar. Matter of Danisar talks explicitly about the potential of entrepreneurs using the NIW to obtain a green card, and certain changes in policy made the NIW a much more friendlier category for entrepreneurs than before. For example, recent updates to the policy manual talks about the types of evidence that entrepreneurs can use to support their case. For example, letters from investors, letters from end users talking about an entrepreneur's product or service and its potential to change the field. Entrepreneurs can also rely on history, showing a history of hiring, revenue growth, tax contributions to support that their future work will have significant positive economic impact to the region or to the nation. Entrepreneurs can also rely on proof of participation in incubators, accelerators, and being awarded investments from venture capital firms and other third-party investors as evidence of the merits of their work. So all of these changes made the NIW an approachable category for entrepreneurs. Now, let's talk a little bit about how the O-1A can be used by an entrepreneur. So as I mentioned in the previous slides, it is possible for an entrepreneur to apply for an O-1A if, for example, they have a separate U.S. entity, a corporation, or a legal entity in the United States that can act as the petitioner. It is okay if the entrepreneur has ownership of the entity in the O-1A context. That shouldn't be a problem. Definitely contact us for a consultation if that is one of the options that you're considering. All right, so I think that is it from what we have. And so let's discuss questions and answers. So it appears we only have one question that came in, and I believe this is relating to the E2 visa. Now, for the E2 visa is outside of the scope of this presentation, so definitely check out our future webinars on the topic of the E2 visa. We have dedicated webinars on that, or reach out to us for a consultation. We'll be happy to discuss that question with you.
Perfect. Thank you so much, GA. I think those appear to be all the questions we have. So we will close here. I hope everybody has a wonderful afternoon. Thank you.